Hello, for those of you who probably would like to have the video content in English, let me give you a very brief account of our discussion. Our topic was international law. What is international law? We said international law is a system of law that is implemented between, at least traditionally, to regulate relations between states. International law, or the idea of international law, was first conceived and developed by European countries. It is a European thought, it's a European tradition. By the time it was implemented and conceived in Europe, most of the world, three-fourths of the world, was out of the scope of international law. So originally it came from Europe. And its subjects were, as I said, basically states, contrary to the situation now, which I will come later to. But in 1648, following the Westphalia Conference, Peace Conference, the idea of international law became more and more visible, more and more understandable, and more widespread. And then scholars, legal scholars, began to write about law. For instance, uh, Grotius, the Dutch scholar, legal scholar, who is considered to be the father of international law, contributed his article, and then that itself helped for the development of international law. Um, Between the period, the 17th century and 1945, the introduction of the United Nations and its charter, international law was not that developed. There were some agreements, treaties here and there, and there were some international events here and there, but we didn't have a well-developed international legal system. Of course, such agreements like the founding agreements of the International Red Cross, 1864, the Hague conferences, the two peace conferences, 1999, 1899 and 2007, the Hague conferences, and the rules and regulations and legal issues discussed there, the formation of the League of Nations in 1999. Oh, in 1919, 1919, um, what have you. These agreements and treaties were there, but as I said, um, a full-fledged legal system, international legal system, um, was not in place. But in 1945, the United Nations was founded, and the Charter of the United Charter was adopted in San Francisco, United States, by 51 countries, and then a new legal order emerged. Among those 51 countries, founding countries, signatories to the United Nations Charter was Ethiopia. Ethiopia was one of the founding member countries of the United Nations, and it was one of the signatories of the Charter. So traditionally, international law was governing just states, but these days, as time passes, as time went by, international law became applicable even to domestic life, to internal societies. It was not limited just to the international community, the international society, but it became relevant to the domestic affairs, to the national communities. Such areas as human rights, labor law, international criminal law became the connecting and linking factors between the domestic societies or national societies or national jurisdiction and international jurisdiction. Therefore, these days, subjects of international law are states, international organizations, and even individuals, as we will see in the future in the international criminal justice discussion. Um, what were the peculiarities or the unique factors or the unique features of the new order, which was introduced in 1945 with the introduction of the United Nations Charter and the United Nations itself? There are about three or four unique factors. One, the introduction of human rights. The idea of human rights, as some people argue, has its origin in 1225, I think 1215, at the introduction of Magna Carta. That document was um, kind of restricting uh, um, agreement, which was developed, which was adopted by the people to restrict the rights and privilege of the king. And that was um, the first agreement, the first instrument where human right, the idea of human right was conceived. This is according to the argument of some scholars. But in the 70s and 8th century as well, such an idea as human right, universal right, were discussed by scholars, by Enlightenment scholars. But human right, in its proper sense, as we know it today, was first introduced with the adoption of the United Nations Charter and the formation of the United Nations. The Charter mentions human rights in 7 places, 7 times, and that shows that the emphasis given to the idea of human rights with the introduction of the legal order. Another unique feature of the new order introduced in 1945 was decolonization. Before 1945, most of African countries, Latin American countries, Asian countries were under the yoke of colonization. But now, with the coming of this new legal order, decolonization occurred, came about, which means that colonization became illegal, and most of the countries became independent since 1945. Um, the third unique feature of the new legal order introduced in 1945 was the incorporation of the right of self-determination. Self-determination was not known before that, but the Charter introduced this new concept of self-determination. So those were some features of the new legal order. Since 1945, various laws were codified, treaties were adopted. Such treaties are the first basis of foundational treaties or declaration or instrument was the Declaration of 1948, the Universal Declaration of Human Rights, and then the subsequent bills of rights like the Universal International Covenants on Civil and Political Rights, International Covenant on Economic, Social, and Cultural Rights, and what have you, were introduced, and torture against treaty against torture, introduction of the child convention of the child, women's, and whatever. So since 1945, so many treaties were adopted, and codification became the main feature of international law. So that was basically um, what we discussed in our previous video in Amharic, and I hope that will help those of you who like the video in English. So thank you for your attention, and hope that will be useful to you. Thank you.